People versus Ortiz, number 201. Counsel, you want any rebuttal time?
Yes, I'd like to reserve 2 minutes of my time for rebuttal.
2 minutes. You have it. Go ahead.
May it please the Court, Ananth Kumar for Mr. Luis Ortiz. Mr. Ortiz's retrial presents two separate errors warranting reversal. First, in contravention of this Court's decision in People v. O'Toole, the prosecution was allowed to present evidence that Mr. Ortiz allegedly used a razor as part of the offense.
What did the first trial demonstrate in regard to the razor?
The first jury's verdict necessarily concluded that the razor was not involved at all.
How? From the burglary 1, burglary 2?
Yes, from the acquittal of burglary 1 involving use or threatened use of a dangerous weapon, and also notably acquitting Mr. Ortiz of robbery in the first degree, also predicated on use or threatened use of a dangerous instrument.
Is it not conceivable that sort of, we don't know exactly why the jury did what it did, or under O'Toole, is it clearly the issue of the razor blade is out?
It is clearly the involvement of the razor blade because the only evidence they heard as to the razor blade's involvement was that Mr. Ortiz allegedly held it to complainant Nunez's throat. Under those circumstances, it is clearly used or threatened to be used, and it is a dangerous instrument. No one disputes that it could sever an artery and cause death.
Let's assume for a minute that you've got somebody who's charged with vehicular homicide and speeding. And because of the lapse of time, the speeding ticket is dismissed on statute of limitations grounds. Okay? Can they introduce the speed in the trial?
Well, Your Honor, in fact, Goodman, I believe, speaks to this, and it recognizes that sometimes there'll be procedural issues that come in to complicate the issue. But here we have a definitive finding and a reasonable finding.
Is that a yes, that they could bring in the speed?
Yes, they
right.
could.
So in this case, they're not going to convict you of robbery first, or any of the charges with respect to the blade. But in order to let the jury know what went on here, why wouldn't they be able to bring in the facts as they evolve? Otherwise, you're deceiving the jury, aren't you?
Your Honor, that same concern came up in People v. O'Toole.
Yeah, it sounds like the dissent in O'Toole, doesn't it?
It certainly does, Your Honor. And the court, the majority of the court, said that you could excise a gun from a forcible robbery case. In that situation, the gun was clearly a central part of their narrative. It explained how the victim was drawn out from the barbershop. If the gun can be removed from O'Toole, despite that concern, the razor can be removed here. And indeed, our case is even stronger than O'Toole because here you already have an account that omits mention of the razor. And here I'm talking about Pura Nunez's 911 call. In that 911 call, she gives a narrative account of what's happening, and she says the thief pushed his way in. She responds to several specific questions by the 911 operator. Is the thief armed? No. The only weapon she mentions...
She was focused on what was happening right then and there and the questions that were being asked of her.
Your Honor, at some point in that call, if it were true that a razor had been held to her throat, her life had been threatened that way, it would have come out, both in narrative form and in response to repeated specific questions. Questions, is anyone hurt? She simply did not mention it, and that explains why the first jury, rejected that portion of complainant's accounts.
Well, there are lots of different narratives here as to what went on. The stories are very different.
There are two competing narratives. There's the complainant's story that this was a dangerous home invasion, and that there's Mr. Ortiz's testimony that this was an altercation because he was being insulted in front of his girlfriend. And what happens...
So you're trying to add a third narrative, right? Because that narrative about the home invasion, you say, can be done without the use of a weapon. Right? So you're actually breaking that narrative down into yet another narrative.
The narrative can be told.
The question is that contradictory? and result is, as Judge Pickett has already said, deceiving the jury.
It is not tantamount to deceiving the jury. The first jury already found, with reasonable basis, that there was no razor involved. Thus, the story.
The jury have found that there was a razor. They had the razor in evidence at the first trial, right? Couldn't they have found that, taken a look at this razor and say, this is completely dull, this isn't capable of causing serious physical injury?
Your Honor, neither of the parties disputed it. No one argued that in summation. The court, in fact, the first jury was instructed.
Does that matter that nobody argued it?
It does when you start to look at this court's precedent, Acevedo, O'Toole, which are talking about realistic, reasonable, rational readings of the record. There is simply no record support for this claim of a non-dangerous instrument. Again, the evidence they heard is that it was held to Ms. Nunez's throat and that her life was threatened in that manner. Under those circumstances, the partial acquittal definitively tells us, just as it did in O'Toole, that they found that the razor blade wasn't involved.
Well, then why did the judge allow it? What was his reasoning?
The judge engaged in a sort of relevance analysis, which seemed to miss the point of collateral estoppel, and that is one reason I believe they let it in. The judge at that time didn't have maybe the clarity, the persuasive force of O'Toole to rely on. The judge's decision was made before O'Toole was decided.
What about the other issue, counsel, the witness issue, the lawyer becoming a witness?
Yes, indeed, Your Honor. Mr. Ortiz was separately prejudiced because the prosecution was allowed to engage in a misleading and unfair impeachment with his attorney's statement from arraignment.
The stipulation did take care of the problem?
The stipulation did not take care of the problem for several reasons. The biggest reason being that the stipulation cannot cure the glaring advocate-witness problem here. So counsel, of course, has to explain, once this impeachment is allowed at all, has to explain to the jury that it was a
Can this
mistake.
never be done? I agree with you. I was kind of surprised that anyone would do it, number one. But then I think counsel cited cases where it was allowed.
Your Honor, the cases that have been cited from this court, Brown, and then the adoption of the decision in Rivera, those are qualitatively different situations. In one of those cases, it was a Sandoval hearing. It wasn't arraignments. You've had hours to discuss, over months to discuss with your client the facts of the case. And in the other, it was a written sworn affirmation. This court has already held in cases like Burgos Santos and Rodriguez, you can't use a withdrawn alibi notice to impeach the defendant. And in that situation, you're switching from something like I wasn't even there to justification. Here, on its face, it's a reasonable mistake. At that time, counsel simply confused razor with knife.
Did the counsel have to be relieved? Did the judge have to relieve the counsel?
Once the impeachment was allowed, the only realistic course of action was a mistrial. Again, this was a credibility contest between Mr. Ortiz and the complainants. Having allowed the impeachment, Mr. Ortiz's credibility was severely damaged. At that point, you can't unring that bell. And you can't simply relieve counsel and have a new counsel step in. The only option was a mistrial at that point. And before...
Another tack here is, how many arraignments had counsel handled that night that Mr. Ortiz was arraigned?
I'm sure she had handled, as she represented on the record as an officer of the court, some 30 arraignments at that point.
Over what time period?
In a single night.
Okay. Was she assigned that night, or had she been assigned before? Was she assigned at arraignment, or?
I do not believe she had any involvement with the case before arraignments.
Okay, counsel, let's hear from your adversary, and then you'll have rebuttal. Counsel.
May it please the Court, Catherine Reno for the Office of the Bronx District Attorney.
Counsel, how could the first trial, how could the razor blade issue not have been determined when they throw out a burglary one and leave two?
Well, there are any number of reasons. One of
What's
which.
their reason? What's the reasoning that would allow the razor blade to be introduced to the second trial?
Defendant has a very heavy burden. He has to establish that they necessarily decided, not that they probably decided.
What else could they have decided in that situation when you know what one requires and you know what two requires?
Well, what they could have, one of the things they could have decided is that this razor, the way it was used, wasn't a dangerous instrument. That was a factual determination to be made by the jury. The razor was in evidence. It was a dull.
The razor wasn't a dangerous instrument? In this particular context?
Yes, there was testimony from Nunez saying that it was against her. It was being held against her neck when defendant was punched. She didn't even sustain a scratch.
If I had a razor against my neck, I might think that that's a dangerous instrument.
Sure, but the jury heard testimony otherwise, and in summations, defense counsel again said, "Oh, it's miraculous that she had this supposed supposed razor to her neck, and yet she doesn't have a scratch.
Let's
that sort of
assume it's a
thing.
razor, not a supposed razor.
And exactly, but she didn't even have a scratch. Therefore, it's very plausible that the jury thought that this wasn't actually.
Is it plausible they don't believe that Mr. I forgot his name, Valenzuela, went at the defendant while the razor is at her neck, and that's why you don't have what you call the nick?
That's possible. I mean,
They don't have to believe everything they say, right? They can
No.
take whatever, they can believe whatever part they want to believe.
Exactly. The point being that that defendant isn't able to show that when they necessarily decided this.
But wasn't your whole theory that he was using a dangerous weapon? That's your entire theory of that case.
That he was using a weapon, and that was how he gained entry. But that is for the jury to decide whether this was an actual dangerous instrument, unlike in O'Toole, where there was an element of a firearm being displayed. The jury just had to find that something resembling a firearm or that appeared to be a firearm was displayed, not that it actually was a firearm. Here, one of the elements was that this razor actually constituted a dangerous instrument. And looking at the court's instructions of what a dangerous instrument was, something readily capable of causing death or serious physical injury in the manner it's used.
So how cutting your vein or
Of course it's possible, but it is also very possible that this jury.
So it's more credible to say that it couldn't have been a dangerous gun than it could have been a razor that wasn't sharp enough to hurt you?
Well, the element is it was different. It was just the display of something that appeared to be a firearm versus that this razor actually
So then how would you
constituted a
use the
dangerous
razor
instrument.
blade in the next trial? In other words, what would be the contentions after the burglary run is thrown out? What's the contention about the razor blade that makes any sense, given what you're saying that's not a dangerous instrument?
Well, the people would be unable to prove their case. I mean, the witness's story without the razor blade is absurd. It's laughable that some guy comes into an apartment building midday in an open lobby, grabs a woman with one hand, and
with the razor blade?
And with the razor blade, it makes a lot of sense because these people are terrified. This woman has a very traumatic experience of having a blade against her throat. That's how defendant's able to push his way into the apartment with absolutely no resistance. I'm sorry.
What makes that credible? Why is Valenzuela lunging at her if there's a blade to her throat?
Because
You're gonna kill her.
he's scared for his wife. He's trying to protect her. It's his gut reaction.
How is that when she's got a razor blade? Your theory of the case, razor blade right at her throat. She testified, I'm scared to death.
Right, and that was his gut reaction was, I'm scared that he's going to kill the woman who I love, and so that was his gut reaction, was punching. It doesn't, that was his
Lunge at him
testimony.
potentially, and he'll slip and slit her throat. It doesn't really make that much sense, does it?
That was his testimony.
Counsel, what about the other issue with the counsel as a witness?
This was completely appropriate in this case.
Can we talk a little bit about this? Because counsel comes in, you're arraigned 30 people in an hour. I don't know. Let's say you're arraigning 30 people, someone you've never talked to before. You talk to them for 2 seconds. You come up and you give a version of events that is inaccurate. It's not under oath. It's not been the product of any stipulation before by anyone else. It's not the product of any sworn statement. You may not even have the papers in front of you, yet you want to use that as if it's a prior sworn statement or testimonial evidence to impeach a defendant. Doesn't that seem to be, well, first of all, it's a little unfair. My friend Judge Lippin is one of the few of us up here who always talks about fairness, and this really does seem to be a bit unfair. I think he's right on that point.
Well, defense counsel was speaking as an officer of the court, and she made very clear that this was based on her conversation with defendant only.
Talking about unfair, why wasn't this raised before the trial began, that you were going to bring this in?
The people didn't have the minutes yet. The people, as soon as they received the minutes, disclosed them to
Which is the third leg of
court.
this thing. I'm surprised as professionals and as lawyers, you wouldn't say to her, by the way, we're going to bring up the fact that your client told you at arraignment what he said. I mean, why wouldn't you tip him off?
It's my understanding that the prosecutor in this case hadn't ever ordered the arraignment minutes, and then this similar situation happened in a trial that his colleague was handling, and he thought, oh, I should check out the arraignment minutes in this case. So he ordered them.
Once this happened, the horse is out of the barn. Why not a mistrial?
Well, first of all, there was no need for a mistrial. The stipulation was able to solve any problems here.
Stipulation cured the problem?
Yes.
You say this and I say that, and that's it?
It couldn't have. All it did is reiterate the statement that was in the record. So you stipulate to the record, but that doesn't take away the unfairness of what's being offered in proof.
It's not unfair. His counsel made clear that she was representing what he had told her. She said, my understanding from Mr. Ortiz is. She didn't say I.
Explanation for that, and her whole credibility, even with the stipulation and the way it was used and the way it was referred to by the people, left her credibility about her reasoning wide open for the jury.
Her credibility wasn't at issue here. That's what the trial court found.
She says, I am incorrect. That's not what he told me. I made a mistake. And then you go and attack. Well, not you, the prosecutor in the trial goes and attacks her, suggests she's perjuring herself.
She's not perjuring herself. It's up to the jury to decide, and the trial court was right.
She says, I was wrong. That is not what he told me. And then the people at trial say, well, it's up to you to decide whether or not that's true or false.
Well, the people didn't have to agree that she made a mistake. There's absolutely no conclusive
You're putting
evidence
her
that she had made a
credibility at
mistake.
issue when you do that.
Why wasn't counsel relieved? Why wasn't she relieved at that point?
She wasn't relieved because she didn't need to be relieved. It wasn't a big.
Someone's statement is an evidence, and they cannot be called to testify because she's ongoing counsel. Didn't she have to be relieved?
No, she didn't have to be relieved. The stipulation protected her credibility in the sense that she wasn't subjected to cross-examination. She didn't have to explain why she made a mistake or how she remembered this.
If halfway through the trial, the people were going to put on a police officer, and for some reason he got the date wrong or he came in late, and the DA said to the defense lawyer, bonehead, got the wrong courtroom. Can the defense then, when the police officer gets on, says, isn't it true that your nickname is Bonehead? I mean, wouldn't that be unfair?
I suppose in that situation it would be unfair, but here counsel was making this representation to gain a favorable ruling. Saying that the understanding comes from defendant himself gives it a certain gravitas. And counsel was trying to get a favorable bail ruling here. So I think that's very different in this context.
True. Then it's argument. And sometimes arguments aren't entirely accurate. So that happens all the time, right? Sure. It happens all the time in the profession. So that being the case, it's not a factual assertion. Once again, it's simply a form of advocacy. If we punish advocacy, how are people going to be able to effectively do their job?
Here it was the stipulation.
See the dangers of this rule that you're pushing. The danger of the rule is that we take, when advocates come in and push the limits of what the truth is or what the facts are, and we start punishing them in a situation where they're advocating, not where they're signing a statement or giving something under oath, we're creating a really dangerous precedent.
Well, otherwise, defense attorneys will be able to misrepresent or lie to the court to gain favorable.
I have it on pretty good authority that defense attorneys are about as honorable as district attorneys.
Okay, well, then I'll end on.
Yeah, can we concede that?
Sure, certainly.
Okay.
Absolutely. But if
Well,
I
it's
could
a
just
general
make
proposition. You're just questioning, you're impugning her in this case, that's all.
just if I could make one final point.
Quick point, counsel.
All of this that she made a mistake was presented to the jury, and it was up to the jury to decide
We understand that
whether
that's
or not this even mattered.
Okay, we get it. Thank you. Counselor, rebuttal.
Yes, Your Honor. No one disputed at the first trial that the razor was a dangerous instrument. You can look at the summations. You can look
Your
at.
adversary says that it's near the throat, but miraculously there's no damage, so not a dangerous instrument.
Your Honor, the judge basically instructed the jury that this involved use of a dangerous instrument, in this case, a razor.
But
No
you're
one-
not going to get convicted of Rob 1 or burglary first or whatever in the second trial.
It's not just about the pure double jeopardy concerns. It's collateral estoppel is recognized because there is unfairness in forcing
You can
a
argue
defendant.
prejudice, but I don't get the collateral estoppel on a simple issue of fact like this.
Well, Your Honor, O'Toole controls here, and this
Regrettably.
court has established since Acevedo.
Your argument is they throw out the burglary one, that's the end of the razor blade, period.
Correct. And in addition, the rob
The
one charge.
robbery.
I don't remember whether did they have the razor blade at the first trial?
Yes.
Okay. Because I was thinking of a scenario where they find the weapon afterwards, or there are facts that now become known that were not known at the time of the first trial. Are they nevertheless precluded from introducing that evidence?
That would be a very difficult and complicated case. I think that would be a very specific case-by-case
Well, it wouldn't be
evaluation.
collateral estoppel is my point. If they did not have the razor at the first trial and nevertheless tried to argue dangerous instrument and they lost, and then they said, we found the instrument, and it turns out it's a straight razor, and it is pretty dangerous, and we want to use that even though we can't convict the robbery first. Could they do it?
Perhaps because the first jury's verdict wouldn't stand as a definitive rejection of that version of events.
Okay, counsel.
Thank you.
Thank you both. Appreciate it.